Good afternoon, and thank you all for standing by, and welcome to today's conference call. At this time, your lines have been placed on listen only for today's conference. Once again, your lines will be on listen only for today's conference call, and our call is being recorded. If you have any objections, you may disconnect at this time. I will now turn conference over to our host, Mr. Phil Ashmore. Sir, you may proceed.
Good afternoon and good morning, everyone. Thank you for joining us and welcome to Module 4 of the webinar series on International Case Processing under UIFSA 2008. My name is Phil Ashmore from the Center for the Support of Families, and we're joined today by presenters Donna Hengeveld, Bill Meyer, and Meg Haynes. 2 points before we begin. Firstly, we've made some minor changes to the original PowerPoint presentation that was sent out. This morning, you may have seen a revised version of the PowerPoint sent by Michelle Butler. If you have that revised version, that's great, but if you are looking at the earlier version, let me just reassure you right now that that also should be just fine for following today's webinar. Secondly, we do have a lot of material to get through today, and we do not expect to have time at the end for questions. So if you're following the presentation online, please type any questions into the Q&A box on screen. Please do that, and we will review those and respond to you after the webinar. Otherwise, you can always email any questions to us at OCSC and we will respond. The email address is ocsinternational@acfhhs.gov. Some of you may have attended earlier presentations where speakers have explained the background to the convention or presented an overview of UIFSA 2008. For others, this information will be brand new. The webinar content has been designed to cover both audiences. The webinar resources include the PowerPoint presentation with notes for the slides and a set of trainer notes that provide supplemental information. The resources related to each particular module will be made available after the webinar on OCSC's website. The first 2 modules of the webinar series were overview modules. They provided background information about the 2007 Hague Child Support Convention, so you will better understand the goals of the United States during the treaty negotiations, the process that was used for negotiating the international treaty, and the terminology in the convention. They also discussed the scope of the convention and services that a central authority must provide, so you'll have a better idea of what to expect on outgoing cases to a convention country. Beginning with Module 3, the focus shifts to case processing. The most likely application under the Convention is an application to recognize and enforce a support order issued by a Convention country. For that reason, there is one module explaining the process and forms for incoming applications, and a separate module, this module, Module 4, explaining the process and forms for outgoing applications. That's applications from the US to other Convention countries. Module 5 examined incoming and outgoing applications for establishment of a support order, including establishment of parentage. Module 6 examined incoming and outgoing applications for modification. Module 7 addresses implementation issues and a comprehensive run-through some questions that have arisen. Finally, in Module 8, we'll discuss processing international support cases from countries that have bilateral child support reciprocity with the United States, but which are not Hague Convention countries. And with that, I'll hand it over to Donna.
Thanks, Phil. So as Phil said, today we're going to focus on outgoing applications from the United States to a convention country, requesting recognition and enforcement of a support order. We're going to discuss your role as the requesting central authority transmitting the application. We're also going to discuss the role of the requested central authority in the convention country and the process under the convention for recognition and enforcement of the order. Because the convention applies to countries with various legal systems, it includes terminology that differs from terms that we use in the United States. This slide converts convention terms to their equivalent U.S. terms. We discussed these terms in prior modules, so we're not going to go over them again today. However, you can always look for those in the trainer notes on modules 1 or 2, which are posted on the OCSC website, for an explanation of each of the terms on this slide. There are two additional terms we will be using today. The convention often refers to a competent authority. There is no definition within the convention because the identity of a competent authority will vary between convention countries, and it also depends on the context of the action. For example, the convention requires the competent authority in the requested state to declare without delay whether a decision registered for recognition and enforcement is in fact enforceable. Depending upon the country, the competent authority might be the court, it might be an administrative agency, or it could be both. Another provision within the convention provides that if there is a challenge to a document submitted for recognition and enforcement, a complete copy of the document concerned, certified by the competent authority in the state of origin, should be provided promptly. It will be up to the state of origin to determine who the competent authority is to certify that requested document. Some of the slides in this module refer to the state addressed. The term means the same thing as the requested state, and it refers to the country that's acting on the convention application. In the U.S., we sometimes use the phrase forum state. In UIFSA, the corresponding term in an interstate case is responding state. Each administrative cooperation convention negotiated by the Hague Conference on Private and International Law requires the contracting state to designate a central authority. The central authority is an agency or organization that is designated to play a key role in the implementation and operation of that treaty. Article 5 of the Hague Child Support Convention lays out general functions of central authorities. They must cooperate with each other to achieve the convention's purposes, and they must try to resolve as much as possible any difficulties that arise in the implementation of the convention. Article 6 of the convention lists specific functions of the central authority. For example, the central authority must both transmit and receive applications. Other convention provisions place additional mandatory obligations on the central authority. These obligations emphasize the need for international cooperation among countries that are parties to the convention. The functions of the central authority may be performed by public bodies or other bodies subject to the supervision of the competent authorities in the contracting state. That means that countries will vary regarding what entity serves as the central authority. However, each country is required to keep the Permanent Bureau informed of the identity of its central authority. That information is available on the Hague website as well as in the country profile that we have discussed in prior modules. In the United States, the central authority is the Department of Health and Human Services, and the Secretary of HHS has delegated the responsibilities of the central authority to OCSE. Article 6 of the Hague Convention lists two specific functions of central authorities. One, they must transmit and receive applications under Chapter 3, and we're going to be discussing those applications in a bit. And secondly, they must initiate or facilitate the institution of proceedings in respect of such applications. Article 6 requires the central authority to take all appropriate measures with regard to the application. One of the specific measures is helping to locate the debtor or creditor. As it does today, OCSE will use the FPLS to assist convention countries when they do not know the U.S. state in which that person resides. However, the information OCSE returns to the convention country is only the state of residence. It will not provide residential or employment address information. HHS has formally designated state 4D agencies as public bodies to perform the functions related to applications under the convention. That means that applications for convention cases are going to continue to be received and transmitted at the state level. The state child support agencies will be responsible for initiating the appropriate proceedings related to that application subject to OCSE supervision. The convention outlines a number of responsibilities that the requesting central authority has when transmitting applications to a convention country, and this slide summarizes them. In its role in the U.S. as a requesting central authority, a 4D agency must help the petitioner complete the application and ensure that the application includes all the necessary information and documents. The country profile is an excellent resource for identifying forms and information that will be needed by the requested state. The 4D agency must also review the application to ensure that it complies with the convention. State child support agencies will need to decide who's going to conduct the review. Will that review be at the local level or centralized with a unit that focuses on convention cases? Note that this review is limited to compliance with the convention. It is not a determination about the merits of the application. Once it is satisfied that the application complies with the convention, the requesting central authority, which is the 4D agency, must transmit the application on behalf of the applicant to the requested central authority. The application must include a transmittal form, which is one of the two mandatory forms under the convention. There's no need to include certified documents unless that's requested by the contracting state. Article 45 of the Convention, which addresses translation, authorizes the requesting central authority to charge an applicant translation costs unless those costs are covered by the country's system of legal assistance. That means that 4D agencies should apply federal regulations regarding recovery of costs related to translation of documents. We will briefly discuss translation requirements again later today in this presentation, but we're going to wait until Module 7 of the webinar for a more in-depth examination of translation issues. An application for recognition or recognition and enforcement is appropriate when there's an existing support order. In the majority of cases, the creditor, also called the obligee, will seek recognition and enforcement of the order. However, the Convention and UIFSA allow a creditor to seek recognition only. That may occur if the creditor is currently satisfied with the debtor's payment but wants to have that order registered in case enforcement is needed at a later point. A debtor or obligor may also request recognition of a convention support order to suspend or limit the enforcement of an existing support order in the requested state. If the requested state issued its own support order or has already recognized a convention order, and that's the order the creditor wants to enforce, then the creditor needs to file a different application. Where that's the case, the creditor would file an application for enforcement of a decision made or recognized in the requested state, because there is no need to request recognition. And we've talked about this before in prior modules, but included in the child support page of the Hague Conference website, it's a wonderful resource titled The Practical Handbook for Caseworkers. The handbook contains detailed information about processing applications under the Hague Child Support Convention. Chapters discuss incoming and outgoing application and include flowcharts, instructions on how to complete the convention forms, and responses to frequently asked questions. And now I'm going to turn it over to Bill Meyer.
Thanks, Donna, and hello, everyone. In the United States, convention cases will continue to be processed at the local level. OCSC will not be involved in the transmission of applications. States are governed by Section 307 of UIFSA, which outlines the duties of the Support Enforcement Agency. The focus of subsection A is on providing services to the petitioner. Regardless of whether your state enacted alternative A or B, you are required to provide 4D services to a petitioner residing in a U.S. state. If the petitioner seeks support from a respondent living in a convention country or having assets in a convention country, you will be transmitting an application under Article 7 of UIFSA. This is the new article that implements the convention in the United States. You may also be assisting a debtor who wants a convention country to recognize an existing order. The first step the agency should take is ensuring that the application request is within the scope of the convention. Applications available through a central authority are listed in Article 12 of the Convention. In the United States, we implemented this article in Section 704 of UIFSA. Under the Convention, the following enforcement applications are available to a creditor: recognition or recognition and enforcement of a support order, and enforcement of a support order issued or already recognized in the requested state. Under the Convention, the following enforcement application is available to a debtor: recognition of an order suspending or limiting enforcement of a previous support order in the requested state. If the petitioner wants recognition and enforcement of a custody order that includes support terms, the only aspects of the order that are appropriate for recognition and enforcement under the Convention are the support terms. The agency must also make sure that the support order the petitioner wants recognized and enforced was issued by a contracting state. As we discussed in Modules 2 and 3, an applicant may use the Convention's procedures for recognition and enforcement of an order only if a contracting state issued that order. The most common example is when a U.S. state will request recognition and enforcement of an order it issued. For example, New York requesting recognition and enforcement of a New York support order. However, another example is illustrated by the second depicted order. In this case, New York is not requesting recognition and enforcement of its own order, but of an order issued by France, a different contracting state. The creditor living in the United States can request recognition and enforcement of the decision made in France, since France is also a contracting state. If the local office determines a convention application for recognition and enforcement is appropriate, the next step is to make sure the agency has all the documents that must be included with the application. Every convention application must include a transmittal using the required convention form. An application for recognition and enforcement must include additional documents. These documents are listed in Article 25 of the Convention. Although the transmittal is a mandatory convention form that all convention countries must use, the countries can decide what form they want a creditor to use for the other required documents. Each country specifies the forms it requires for recognition and enforcement within its responses to the country profile. As discussed during Modules 1 and 2, the country profile is maintained on the Child Support section of the Hague Conference website. It is the resource that most contracting states use to inform the Permanent Bureau and other convention countries of their child support laws and procedures. In reviewing the country profiles listed on the Hague Conference website, it appears that almost all of the countries want applications to use the recommended forms published by the Hague Conference for use with an application for recognition and enforcement. I'm going to turn it over now to Meg Haynes for a little bit more information about required documents.
Thanks, Bill. So this slide and the next ones identify the documents that are required by Article 25 of the Convention. The first column lists the document. The second column explains when the document is used. And the third column identifies the applicable convention form unless the country has identified an alternative preferred form in its country profile. If there's not a standardized convention form, you can use a form that your state or office has developed, again, unless the country has identified an alternative preferred form. As we discuss in these next slides, there are 3 places within Article 25 where a country may specify its document requirements. Some of you may have already noticed that not every country has completed a country profile. So although the country profile is where you should go to first, another resource is the status table on the child support page of the Hague Conference website. The status table lists all the countries that have ratified or acceded to the convention, as well as the country's reservations, declarations, and notifications. And often these notifications include any special document requirements of a country. In a minute, we're going to go over the forms listed in the chart, but for now, note that you are required to include the complete text of the order with the application unless the requested state has indicated that it will accept an abstract or extract. As we just explained, the country profile and the status table are the best resources to learn whether a country will accept an abstract. When you send the text of the order, it can be in electronic form. You don't have to initially send a certified copy of the order. The only exception would be if the contracting state has specified that it does want a complete copy of the decision certified by the competent authority in the state of origin. And again, that would be noted in the country profile. It may also be highlighted in the status table. The only documents the Convention requires with every application for recognition and enforcement of an order are the transmittal, the application, and a document stating the order is enforceable in the issuing country. The remaining documents listed in the chart have to be produced only if necessary, depending on the circumstances. For example, if the order was issued by an administrative authority, the Convention requires a document stating that the administrative decision was subject to appeal or review by a judicial authority and that the decision has the same effect as a judicial decision. There are two exceptions to this requirement. One is if the requested state has indicated it doesn't require such a document, and the other exception is if the issuing country has specified that all of its administrative child support orders meet those requirements. And the good news is that the U.S. has so specified in its country profile, and that means if you're in a state that issues support orders administratively, you do not have to send a document saying your decisions meet Article 19, subsection 3 requirements. The U.S. has already kind of done a blanket statement to that effect. If you're seeking enforcement of arrears, there's no recommended convention form or format to use for the record of arrears. Check the country profile to see if the requested state has a preferred form. And if not, whatever document you send should show the amount of arrears and the date the amount was calculated. If a support order is supposed to be indexed automatically or adjusted on a specified frequency, for example, the order includes a cost of living adjustment, a COLA, then you've got to provide details in the application package about how to do that adjustment. For example, if the adjustment is to be made using a cost of living percentage, then you should provide details about whether your state will be calculating the adjustment or if you're asking the requested state to do so. You need to send information about how the adjustment is calculated, and if your state is doing the adjustment, information about how the recalculated amount of support will be communicated to the requested central authority and the parties. According to the explanatory report of the Convention, this information doesn't have to be a formal document. Any informal document, like an email or a fax, is sufficient. The explanatory report also notes that any subsequent decision that adjusts the support amount does not have to go through the full recognition process. The initial recognition contemplates these future adjustments. A requested state must provide free legal assistance, if needed, with respect to a creditor's application for recognition and enforcement of a child support order. And that means you do not need to provide any kind of documentation about legal assistance when you're seeking an application for recognition and enforcement and you're helping a creditor. However, under Article 17 of the Convention, for other applications, like an application for recognition brought by a debtor or an application for establishment of order, then the contracting state may make the provision of free legal assistance subject to a means or a merit test. The exception is if the applicant benefited from free legal assistance in his or her state of origin, and then the applicant is entitled to at least the same level of free legal assistance as provided for by the law of the requested state under the same circumstances. So in other words, the requested state doesn't have to change its laws and provide free legal assistance for these other applications, but the applicant should at least be treated the same as a local resident would be under the same circumstances. And the documentation noted on the chart is what would be needed in that situation. There's no recommended Hague Convention form. So if you're assisting a debtor with an application for recognition of a support order, you're going to need to send a letter or some other document explaining if your agency provides free legal assistance to recipients of 4D services. The financial circumstances of the debtor or obligor are always required when you file an application for recognition and enforcement. We're going to discuss the financial circumstances form in a few minutes, but for now, I'll turn it over to Bill to walk us through the transmittal form.
Thank you, Meg. Every application for recognition and enforcement must be accompanied by the convention transmittal form. The form identifies the parties and the type of application. It also indicates the documents that accompany the application. It is very similar to the Child Support Enforcement Transmittal Number 1 that we use in the United States in intergovernmental cases. The preamble to the transmittal recognizes that there are situations where the release of any personal information could jeopardize the health, safety, or liberty of a person. If your agency, as a requesting central authority, has determined that this presents such a risk, you should check the tick box indicating a determination of non-disclosure has been made. Sections 1 and 2 provide information about the requesting central authority and the person who should be contacted if the requested state has any follow-up questions. For the address of the requesting central authority, use the address of the local agency working the case. Presumably, that will also be the address of the contact person, so there would be no need to add an address in Section 2. Section 3 is self-explanatory. You can find the address of the requested central authority in the country's country profile. Because not all countries have completed a country profile, you can also find the central authority's address by clicking on the word authorities on the right-hand column of the child support page of the Hague Conference website. Section 4 requests the name and date of birth of the applicant. In an application for both recognition and enforcement of a child support order, the individual applicant may be the person for whom support is sought or payable, such as a parent of a child, or the child. In the United States, we usually refer to that person as the obligee. The applicant may be the legal representative of the person for whom support is sought or payable. A public body may also be the applicant, where the public body is providing assistance in lieu of maintenance. Section 5 of the transmittal requests information about the person for whom support is sought or payable. This person may be the same individual as the applicant. For example, an applicant who is seeking enforcement of a spousal support, seeking enforcement of spousal support. However, if you list the custodial party's name as the applicant and you want recognition and enforcement of a child support order, in Section 5 you would provide the names and dates of birth of the children who benefit from the support order. The transmittal provides space for the names of 3 children. In Section 6, you should provide details about the debtor. As you can tell, this is basic information. More information about the debtor will be included in the application form and in the financial circumstances form. Section 7 contains tick boxes for you to indicate which application the transmittal is accompanying. The article references are to the Hague Child Support Convention, not UIFSA. Use the Caseworker Handbook as a quick reference to the correct article. You may also view the text of the convention itself. Both are available on the Child Support page of the Hague Conference website. The correct tick box for a creditor's application for recognition and enforcement is the first one, Article 10(1)A. Section 8 of the transmittal lists the documents that must be included with the application. You will use Section 8A when sending a creditor's application for recognition and enforcement of an order. Check all the boxes that apply to your application. Notice that after the first set of tick boxes, there is a second set of tick boxes introduced by the phrase, in accordance with Article 33. Do not check any of these final tick boxes. They are only used where the application is for recognition of a maintenance arrangement. Section 8B applies to different applications than the ones we are discussing in this module, so do not check any boxes within it when you are sending the creditor's application for recognition and enforcement. Finally, note the transmittal does not require a signature. Rather, there is a block for the name of the authorized representative of the requesting central authority who is completing the form. In most states, that will be the caseworker handling the case. I'm going to turn it back to Meg to talk about the application.
Thanks, Bill. So this is the recommended convention form for the application for recognition or recognition and enforcement. And most convention countries have indicated in their country profiles that this is the form they want states to use. As is true for all applications, the first section of the application provides a confidentiality and personal data protection notice. If there's concern that disclosure of identifying information would jeopardize the applicant's health, safety, or liberty, then don't provide the information requested in Section 2. You would place a check mark in the appropriate box on the application form, and you would include the personal information on the separate restricted information form, which is found at the end of the application. After listing your file reference number, in the U.S. that's going to be your case number, you will be providing information about the applicant. If the applicant is an individual, there are 4 options. The individual applicant may be the person for whom support is sought or payable, such as a spouse, a parent of a child, or the child. In the United States, we usually refer to that person as the obligee. The applicant may be the legal representative of the person for whom support is sought or payable, or the applicant may be the debtor or a representative of the debtor. And in the United States, we usually refer to the debtor as the non-custodial parent or the obligor. You will usually check the box indicating the applicant is the person for whom maintenance is sought or payable. The family name would then be the obligee's last name, and the given name is the obligee's first name. This is the bottom half of page 1, and it includes information if the applicant is a public body. For the purpose of an application for recognition and enforcement, Article 36 of the Convention allows a creditor to be a public body acting in place of an individual to whom maintenance is owed, or one to which reimbursement is owed for benefits provided in place of maintenance. So if the public body is the applicant, you would complete fields A through C as appropriate. If you notice, whether the applicant is an individual or a public body, the fields are lettered A, B, and C, and in either case, you then need to also complete fields D through G, which are noted on this slide. These lines require text information, not the checking of a tick box. They ask for the applicant's address, phone number, fax number, and email address. According to the explanatory report, the contact information is important so the applicant can receive the notices required under the Convention. Pursuant to OCSC guidance, you should use the agency address as the address for the individual applicant in all 4D cases, both public assistance and non-public assistance. The reason OCSC wants you to use the agency address is to ensure you receive notices that are required by the Convention. Section 3 of the application provides information about the individual for whom support is sought or payable. If the applicant is seeking support for himself or herself, indicate that in Section 3.1. For example, if the applicant's a spouse and the application seeks recognition and enforcement of an order providing for spousal support as well as child support, this would be an appropriate box to check. The basis for the support duty must also be checked. And if it's spousal support, the tick box marriage should be checked. Some tick boxes, such as affinity, are not relevant to the U.S. because we have not extended the Convention to family relationships such as an uncle, like some countries have. The more common scenario will be the applicant who is a parent or a public body seeking recognition and enforcement of a child support order. And in that case, Section 3.2 needs to be completed. For each child, provide the full name and date of birth. The Handbook for Caseworkers says to use the name that appears on the child's birth certificate. The application must also state the basis for the child support obligation. Check parentage, if the children were born during the marriage, so parentage is presumed, or if there's been a legal determination of parentage. The Practical Handbook for Caseworkers says to also check this box if there are genetic test results establishing a connection between the parent and child. If the child is the applicant, only Section 3.2 needs to be completed. Complete Section 3.3 if maintenance is sought or payable for someone other than the applicant or child. And check tick box in Section 3.4 if support is sought for additional children. In that case, you're going to need to attach information for the children in the same format as used for the 3 children named in Section 3.2. If the applicant is the debtor, you would complete Sections 4.1 and 4.2 of the application. Today, we're focusing on a creditor's application for recognition and enforcement, so we're not going to review these sections, but you can check Chapter 15 of the Practical Handbook for Caseworkers to get information about how to fill out these sections. In Section 4.3, you should provide information that will help in locating the respondent. The personal identification number for a U.S. resident is the Social Security number. Section 5 provides information about where you want support payments to be sent. Don't complete this section if there's concern that identification of the bank or SDU location would create a risk to the applicant. In that case, you would use the restricted information form, which includes an entire section on financial circumstances. But if you're not concerned about the disclosing this information creating any kind of risk of injury, then you would complete Section 5. And subsection A focuses on EFT payments. And if payments are by check going to the SDU, those details would be included in subsection B. In both subsections, make sure you provide the correct file or account reference number so that payments can be properly identified. An applicant would check tick box 6 if the application is for recognition only. If you're helping a debtor, that tick box may be appropriate to check. Section 7 of the application is particularly important. This is where you will identify the applicable basis for recognition and enforcement of the order. Check all boxes that may apply. I'm going to repeat that. Check all of the boxes that may apply. And let me explain why that's important. Let's look at tick boxes 1, 2, and 4 on the form. They're similar to bases under Section 201 of UIFSA. So if jurisdiction over the respondent was based on one of those long-arm bases of jurisdiction, you would check the applicable box on the form. In all likelihood, the creditor in the case probably resided in the issuing state. And if the creditor did reside in the issuing state, you would also put a check in the third tick box, even if that's not the basis of jurisdiction the U.S. tribunal used. Can you go back to the prior slide? Thank you. Section 201 of UIFSA also includes some bases of jurisdiction that are not bases for recognition under the Convention Article 20. Those are personal service while the respondent was in the state, presence of the child in the state as a result of acts or directives of the respondent, and intercourse in the state that may have resulted in conception of the child. Again, in most of those cases, the creditor resided in the issuing state, and that is a basis for a convention country to recognize the U.S. order. Therefore, if applicable under the case facts, you would check that tick box related to creditor being resident in the state of origin. And if you use a basis for jurisdiction under Section 201 that's not listed under the convention, that creditor residence tick box would be the only box you would be able to check. Next slide. As discussed during Module 3, in order for an order to be recognized or recognized and enforced, the requested state must be satisfied that the respondent had notice of the support proceeding as required by the law of the issuing state and had an opportunity to be heard or was represented in the proceeding. Section 8 of the application covers this requirement. You would indicate whether the respondent appeared or didn't appear in the issuing state and whether the respondent was represented. Usually, a U.S. tribunal makes express findings about notice and appearance in the support order, so it'll be easy for you to determine what you should be checking. If the respondent did not appear and was not represented, the competent authority must confirm that the respondent had proper notice as required by the law of the state where the decision was made. As discussed earlier, the statement of proper notice, which is one of those recommended Hague forms, accomplishes that. If the decision was made in an administrative system where no hearing is required, then you have to always include a statement of proper notice. You will also check the tick box in Section 9 if you are seeking recognition and enforcement of a support order, and we'll discuss the financial circumstances form in a few minutes, but that will be important in every recognition and enforcement case. This slide depicts page 5 of the application for recognition or recognition and enforcement. In certain circumstances, a requested state may use a means or merit test in determining whether to provide legal assistance to an applicant. Those two circumstances are outlined in Section 10. However, in most of your cases, where an application for recognition or recognition and enforcement of a child support order is made by a creditor, the requested state is required to provide free legal assistance, and you don't need to complete Section 10 of the application. The exception is if you are helping a debtor with an application for recognition, and then you would need to check that second tick box. The financial circumstances form addresses the means test. In the situation where the debtor is receiving 4D services, you should provide information substantiating that the debtor can benefit from free legal assistance in the issuing state, if that is accurate. The final page of the application also includes an attestation at the end. Note that the application is not signed under penalty of perjury, so that's different than our intergovernmental forms. With the application, an authorized representative of the requesting central authority attests that the application was completed by the applicant and reviewed by the requesting central authority. Further, the representative attests that the application complies with the requirements of the convention, that the application and accompanying documents are the same as those provided by the applicant to the requesting central authority, and that the applicant has consented to the forwarding of the application to the requested central authority. In most U.S. states, the authorized representative will be the caseworker in the local office who assisted with the application preparation. And I'll turn it over to Donna now.
Thanks, Meg. So as Bill noted for the top of the transmittal and Meg covered for the beginning of the application form, there's that tick box. And if you've determined that certain identifying information shouldn't be disclosed or confirmed for the protection of the health, safety, or liberty of a person, for example, you have the case flagged with a domestic violence indicator, this is the form that you're going to include with the application for recognition and enforcement. Under the convention, the determination by a requesting central authority has the same purpose as the allegation by a party under Section 312 of UIFSA. This form is entitled Restricted Information on the Applicant, and it segregates personal and financial information about the applicant. So this is the bottom half of the form. Note that the numbering is not sequential because it conforms with the section numbers on the application for recognition and enforcement where identifying information is provided. As Meg mentioned, because bank account information may be helpful to identify the location of a person, Section 5 segregates that information. There is a separate restricted information form for the financial circumstances form. The remaining tick boxes are at the bottom of all convention applications. The first one indicates whether the application was completed by the applicant and reviewed by the requesting central authority. The second tick box should always be checked. It states that the application complies with convention requirements and that the applicant consents to the application being forwarded to the requested state. The name of the authorized representative of the Child Support Agency should appear at the bottom of the page. An application for recognition and enforcement should always include the order itself, unless the requested state has indicated that an applicant can include an abstract or extract of the order drawn up by the competent authority in the issuing state in lieu of the complete text. To date, only 5 of the contracting states have indicated in their country profile that they will accept an abstract or extract in lieu of the complete text. An abstract is especially useful if you've got a long order and only part of it relates to child support. If an abstract is acceptable, then instead of translating the entire order, only the abstract or extract needs to be translated. An acceptable form for the abstract is the recommended form published by the Hague Conference. As noted on the slide, the abstract provides a place to indicate whether the order was issued by a judicial or administrative authority. The form continues for several pages and summarizes the key components of the order as it relates to child support. Most of the sections are self-explanatory. Section 5 provides information about specific terms of the order. There are places to list each person for whom support is owed. As noted earlier, the family name is the individual's last name and the given name is the individual's first name. There are places to note the terms of current support, payment of arrears, payment of retroactive support. In listing the currency, use the applicable ISO code. That's a 2-letter code that is an abbreviation for the country. For a U.S. order requiring support, you would note the dollar amount of support followed by the code US. The abstract also lists terms related to interest, health insurance, school fees, and lump sum payments. There's a catch-all place to note other required payments. If the child support order requires support for more than one person on an individual basis, use Section 5.2. That's most likely to occur when the order establishes an amount of support per child. As you can tell, Section 5.2 mirrors Section 5.1. Section 5.3 will rarely apply unless the order requires specific payments to the Child Support Agency for public assistance provided. Don't complete Section 5.3 simply because support payments go through the SDU. It is the public body's entitlement to support payments under the order, not the location to which payments are directed, that controls whether you need to complete Section 5.3. Section 6 of the abstract only applies if the order provides for automatic adjustment or indexation. For example, if your state uses the cost of living adjustment, you would complete this section. Section 7 covers interest if it applies. Section 8 addresses the duration of the support order obligation. Now keep in mind that the mandatory scope of the convention requires the recognition and enforcement of current support to age 21. Enforcement beyond age 21 depends on domestic law. Section 9 addresses costs and expenses. Such costs might include genetic test fees. The bottom of the form contains 2 name blocks. One is the name for the official from the competent authority in the state of origin. Because state refers to the issuing country, it's OCSE policy that a representative of a 4D agency can sign as the competent authority, summarizing the terms of a support order issued by its state or another U.S. state. The other block is for the name of the representative of the requesting central authority that is forwarding the abstract. That central authority representative indicates that the named official from the competent authority completed the abstract and that the central authority representative is transmitting the abstract to the requested central authority. In the U.S., the authorized representative of the requesting central authority will usually be a caseworker in a local office processing the case. So the bottom line is, it is appropriate for the same child support caseworker or attorney to sign as both the competent authority and the authorized representative of the requesting central authority. And now I'm going to turn it over to Bill.
Thanks, Donna. Another document the convention requires is a document stating that the support order is enforceable in the issuing country. Unless the requested state has specified otherwise, use the recommended convention form to comply with this requirement. Titled Statement of Enforceability of a Decision, it provides contact information about the competent authority issuing the statement, as well as information about the authority that issued the decision. As we will discuss in a minute, the competent authority may be a representative of the 4D agency in the requesting U.S. state or in the state that issued the order. The bottom half of the statement includes more information about the decision, the date it was issued, its effective date, the reference number, and the names of the parties. Section 4 is the most important tick box. That's where the competent authority indicates that the order is enforceable in the state of origin. So if it's a U.S. order, you would be stating that it is enforceable in the U.S. In other words, it's the controlling order in the case. There are two name blocks on the form. One is for the name of the official from the competent authority in the state of origin. Many states have asked who can sign as the competent authority. Child support orders entered in the United States are subject to the due process requirements of the United States Constitution, and in domestic cases, UIFSA and Full Faith and Credit for Child Support Orders Act require recognition of child support orders issued in other U.S. states. Therefore, in an outgoing application for recognition or recognition and enforcement of a U.S. order from a U.S. state to a convention country, the child support agency in the requesting U.S. state may complete the statement of enforceability, whether or not its state issued the order. It should check the state and federal case registries and identify possible controlling order issues before preparing the statement of enforceability. The other name block is for the representative of the requesting central authority that is forwarding the statement of enforceability. That central authority representative indicates that the named official from the competent authority completed the statement of enforceability, and the central authority representative is transmitting the statement to the requested central authority. If the respondent did not appear and was not represented in the proceedings in the issuing country, the convention requires that the application for recognition and enforcement include a document attesting to proper notice and an opportunity to be heard. Unless the requested state has specified otherwise, use the recommended Statement of Proper Notice published by the Hague Conference. The first part of this form identifies the competent authority in the state of origin who is issuing the statement. As we discussed in Module 2, the identity of the competent authority will vary among countries. What is important is that it be an official in the issuing country who is able to confirm that the respondent had proper notice as required by the law of the country that issued the order. As we noted when discussing the statement of enforceability, a competent authority in the U.S. for completing the statement of proper notice may be a representative of the 4D agency in the requesting U.S. state or in the state that issued the order. Section 3 of the form provides information about the order, including the authority that issued the order, the date of the order's reference number, which is the number assigned by the court or administrative tribunal, the names of the parties, and the name of the respondent. Part 2 of the form includes the information about notice. In Section 5, the official from the competent authority of the state of origin indicates the type of notice and opportunity to be heard that the respondent received. There are two options. The first tick box states that the respondent received advance notice and had an opportunity to be heard. States using a judicial process will check this box. The second tick box indicates that the respondent received notice of the decision and had an opportunity to challenge or appeal after the decision was rendered. If you're an administrative process state, check the appropriate box. As with the statement of enforceability, there are two name blocks on the form. One is for the name of the official from the competent authority in the state of origin. As noted earlier, because U.S. child support orders are subject to the due process requirements of the United States Constitution, and the Full Faith and Credit for Child Support Orders Act requires recognition of child support orders issued in the U.S., a representative of the child support agency in the requesting U.S. state may complete the statement of notice, whether or not its state issued the order. The other name block is for the representative of the requesting central authority that is forwarding the statement of proper notice. Now we're going to talk about the financial circumstances form a little bit. The financial circumstances form is another recommended form published by the Hague Conference. If the applicant is seeking both recognition and enforcement of the order, which will happen in most cases, you should include this form. As with other documents in the application, there is a place on the form to indicate whether there is a concern that the disclosure or confirmation of the information would jeopardize the health, safety, or liberty of a person. In such a case, the personal information will then only appear in the restricted information form. Indicate in Section 3 whether the applicant is a creditor, debtor, or a representative of the person for whom maintenance is sought or payable. Section 4 identifies the application that is being made. You do not need to check the box about applying for legal assistance when a creditor is seeking recognition and enforcement of a child support order. Legal assistance is mandatory if necessary in the requested state. However, if you are assisting a debtor seeking recognition of a support order, you should check this box in addition to the box for the specific application. In Section 5, indicate the currency that is used throughout the financial circumstances form. Currency conversion is not required. However, if you have converted all amounts to the currency of the requested state, indicate the exchange rate used and the date of the conversion. Although you should submit the financial circumstances form in conjunction with the application for recognition and enforcement, not every section of the form is relevant. You do not need to complete the creditor portion of the form, since that information is not required for an application for recognition and enforcement. Financial information about the creditor is only relevant for applications to establish or to modify. The sections that should be completed are those related to the debtor or obligor. Part 3 of the form provides information about the debtor. It should be completed for all applications. Section A identifies the debtor's employment, earnings, and present marital status. Section B identifies all of the debtor's dependents, including dependents in the debtor's current household. Section C provides income information about the debtor's current spouse, partner, or other household member who is contributing to the debtor's household expenses. Depending upon the laws of the requested state, the availability of such income may impact enforcement. Part 4 should also be completed for all applications. Section A lists the debtor's assets. Complete it to the extent information is known. Section B of Part 4 lists any known debts of the debtor. You do not need to complete Part 5 when sending an application for recognition and enforcement. This part is only completed if the application is for establishment of an order, modification of an order, or where legal assistance is required in the limited circumstances set out in Article 17 of the Convention. Part 6 of the Financial Circumstances Form addresses medical insurance. I'm going to turn it back to Donna.
Thanks, Bill. So OCSC issued DCL 1621, which provides guidance and information about the mandatory and recommended convention forms. It has also formatted the forms into a fillable PDF format, which you can access from the OCSC website. Now, we had a report this morning that there might be some issues that could be improved with it, so thanks to California for pointing that out. We will be looking into it. OCSC is working with the Permanent Bureau to identify translated convention forms for the other Hague countries. Right now, the forms are also available in French and bilingual German-English. Keep in mind the Hague Convention forms were developed with lots of tick boxes so that the content itself needs minimal to no translation. When preparing Hague forms in another language, OCSC suggests laying the English version and the foreign language version side by side so you can easily transfer the information to the foreign language form. It is OCSC's understanding that there is a plan for each country to provide an approved version of the translated form in its own language to the Hague Permanent Bureau. As soon as these translated forms are available, OCSC will make them available to states. This slide depicts OCSC's international page and shows where you would click to access the Hague Convention form. Article 44 of the Hague Child Support Convention addresses translation of documents and communication. Any application and related documents must be in the original language and must be accompanied by a translation into an official language of the requested state or another language which the requested state has declared it will accept, unless the competent authority of that state dispenses with translation. Unless otherwise agreed by the central authorities, any other communications between authorities must be in an official language of the requested state or in either English or French. However, a contracting state may make a reservation objecting to the use of either English or French. For example, the U.S. has objected to the use of French when a central authority communicates with us. So if a country's made such a reservation, it will be noted on the status table on the Child Support page of the Hague Conference website. You can also learn about a country's language requirements by checking its country profile. And now I'm going to turn it back to Meg.
Thanks, Donna. Before transmitting the application, Article 12 of the Convention requires the requesting central authority to review the application to ensure it complies with the Convention. One implementation question a State 4D agency needs to answer is whether applications will go directly from the local 4D office to the requested central authority in the other country, as currently done in international cases, or whether the agency wants to centralize a final review of all outgoing Convention applications. Currently, there's no federal requirement to centralize the review or transmission of an application, but some states are considering centralization in order to establish expertise in Convention provisions. Specialization in international case processing is something OCSC encourages, and they'd like to work with states to share best practices as you begin to implement the Convention. The next slides focus on what happens once the 4D agency has transmitted an application for recognition and enforcement to the requested central authority in the Convention country. How do you know where to send the application? Where do you find the address of the country's central authority? Well, for that, you check the country's profile. And as noted earlier, if the country has not completed a country profile, you can also find information about the central authority by clicking on the word authorities on the right-hand column of the Child Support page of the Hague Conference website. With this slide, we begin a focus on the role of the requested central authority in the Convention country. What happens when it receives this application from the U.S.? Article 12 of the Convention was important to the United States during treaty negotiations because it contains time frames. This is really unusual for a Hague Convention and is an example of how important it was to the U.S. that the treaty addressed the practical issues of delays in case processing. The Convention requires the requested central authority to acknowledge receipt of the application within 6 weeks. There is a mandatory acknowledgement form that has to be used for that, and the acknowledgement will also inform you about what initial steps have been taken. It will identify any needed additional documents and will provide contact information. Within 3 months of the acknowledgement, the central authority in the requested state is also required to provide a status update. That's not something you have to request. That initial status update is supposed to be provided automatically. The requested central authority also is required to review the application that you sent. In its review, there are 2 important provisions that govern. First, the requested central authority may refuse to process an application only if it's manifest that Convention requirements are not met. And second, the central authority may not reject an application just because additional documents or information are needed. In the rare case where the requested central authority does decide to refuse to process the application, there must be prompt notice to the requesting state. We talked about each of these provisions during Module 3, but we'll review them again. First, the central authority may refuse to process the application only if it's manifest that Convention requirements are not met. According to the Convention's explanatory report, manifest means it has to be clear on the face of the documents that the requirements are not fulfilled. The explanatory report gives the following example of when it might be manifest that convention requirements are not met. And that's an example where the party previously submitted an application concerning the same debtor. That application failed on a specific ground, and now the applicant submitting the exact same application with no change of circumstances. That might be one where the central authority refuses to process the application because it's manifest that convention requirements are not met. There's a second important provision governing the requested central authority's review. It may not reject the application for recognition and enforcement solely because additional documents or information are needed. If additional information is needed, the requested central authority must ask you for the information. If the information or documents are not provided within 3 months or whatever longer time period is specified, the convention allows the country to decide not to process the application. Hopefully that situation is never going to arise with an incoming application from the U.S., because I know you'll do your best to timely provide the information requested. But if that is the decision ultimately made by the requested central authority, it must let you know of that decision. The convention requires the requested central authority to acknowledge receipt of an application within 6 weeks. As I mentioned earlier, the convention does have a mandatory acknowledgement form, so you'll be receiving the same form from every convention country to which you send an application. The acknowledgement identifies any needed documents and provides contact details of the person responsible for processing the application. We reviewed the acknowledgement during Module 3, but Donna is going to look over the form with you again now.
Thanks, Meg. So the acknowledgement form begins with the standard notice of confidentiality and personal data protection. It identifies the requested central authority as well as the contact person for any follow-up questions about the case. The form also has a place to list the languages spoken by that contact person. Section 4 of the acknowledgement is where the requested central authority would acknowledge receipt of the application for recognition and enforcement. The articles listed are, as we've mentioned before, are references to articles within the Hague Child Support Convention, not sections of UIFSA. So for purposes of our discussion today, the requested central authority would be checking the first box to acknowledge receipt of an application for recognition and enforcement of a convention order. The acknowledgement includes areas for the requested central authority to provide the family name of the applicant, the person for whom maintenance or support is sought or payable, and the debtor. That information is going to come from the transmittal that you sent them along with the application. Section 5 of the acknowledgement is where the requested central authority notes what initial steps have been taken. There are tick boxes to indicate whether the file is complete or whether they're requesting additional information or documentation. There's also a tick box to indicate if the requested central authority refuses to process the application because it is manifest that the requirements of the convention aren't fulfilled. As we discussed earlier, if that rare action is taken, they must provide the reason. Finally, there is a standard request that the requesting central authority keep the requested central authority informed of any changes in the status of the application. Now you'll note that the form isn't signed. However, the name of the authorized representative of the requested central authority should appear on the form. The convention outlines general case processing responsibilities that the central authority has when receiving applications from a convention country. And this country summarizes the measures that Article 6 requires if appropriate. And we discussed these in Module 2 of the webinar. If you recall, the required role of the requested central authority is usually to facilitate or help with these measures. Ordinarily, a requested central authority will process applications quickly without the need for additional formal documents requesting assistance. However, under certain countries' domestic laws, there must be a power of attorney in order for the central authority to act on behalf of the applicant. So in that limited circumstance, Article 42 permits a central authority of the requested state to require a power of attorney from an applicant in order to represent the applicant before authorities. The country profile will let you know whether a power of attorney form is required. This slide assumes that the application for recognition and enforcement has been processed and not rejected by the requested central authority. That's going to be the common circumstance. The next steps depend upon the requested state's procedures. In some countries, it may be possible for the requested central authority to determine if the order can be registered for enforcement or declared enforceable. In other countries, the requested central authority can't make that determination. In those countries, the requested central authority must promptly refer the application to the appropriate competent authority. In both cases, the responsible authorities must act promptly or without delay in registering the decision or declaring it enforceable. And now I'm going to turn it back to Meg.
Thanks, Donna. So now we're going to shift to the role of the competent authority. And to the extent that there's no conflict with convention procedures, the competent authority in the state addressed, that's the country where you sent the application for recognition and enforcement, is going to be following its own laws and procedures. But the convention does contain certain requirements to ensure the country uses an expedited process for recognition and enforcement, and the main provisions for that procedure are in Article 23 of the convention. The objective is to establish a procedure that is simple, speedy, and low cost. And as you can imagine, it took many years of negotiation to reach consensus on what that procedure should look like. Ultimately, Article 23 requires a procedure for the registration of a foreign order for enforcement or for a declaration of the order's enforceability that excludes submissions of evidence from the parties unless there's a challenge. You know, in the United States, we use a registration procedure, but that's not universal, which is why you're also on these slides will see a reference to a declaration. The Article 23 procedure limits available challenges and also limits the ability of the competent authority in the requested state to review the order on its own motion. Under the convention, a competent authority may refuse a declaration or registration only if recognition of the order would be manifestly incompatible with the public policy of the state addressed. And this is the only ground on which the competent authority may review ex officio the application. Under Article 23, the parties must be notified of the registration or declaration of enforceability, as well as of any refusal to register the order because recognition would be manifestly incompatible with the public policy of the state addressed. The Convention uses the terms challenge and appeal to cover both judicial and administrative systems. The objective of both terms is the same. It's to allow the party a chance to oppose the decision first made about recognition of the foreign order. The Hague Convention contains specific time frames that all contracting states have to follow, and you'll see those time frames in the U.S. implemented in Section 707 of UIFSA. When you send an application for recognition and enforcement to a convention country, if the requested central authority refuses to process the application because recognition of the order would be manifestly incompatible with its country's public policy, the applicant has 30 days from the notice of that decision to appeal. Assuming the convention country registers the order or declares it enforceable, the respondent must file a contest within 30 days after notice of the registration or declaration. And if the contesting party does not reside in the state addressed, for example, the obligor has bank accounts in Spain, so that's where you sent the application, but the obligor actually lives in Morocco, then the obligor can file the contest not later than 60 days after the notice. Since the great majority of applications for recognition and enforcement will be successful, delegates during the treaty negotiations agreed that the time allowed for challenge or appeal should be brief. So we were happy to see this 30 to 60-day time frame. Because the goal is to have an expedited process for recognition and enforcement of support orders, the Convention limits the right to challenge or appeal. Article 23 lists the only bases for challenging the registration. First, one or more of the grounds for refusing recognition and enforcement under Article 22 is present. Another basis for challenge is that there's no basis for recognition and enforcement under Article 20. A challenge can be raised based on the problem with the authenticity or integrity of a document transmitted under Article 23. And finally, another ground for challenge or appeal may be founded on payment of the support arrears, to the extent that recognition and enforcement relates to past due payments. At this stage, the procedure becomes adversarial, and that means that both parties may present evidence and have an opportunity to be heard. The next slides talk about each one of these grounds for challenging the registration or declaration. In an application for recognition and enforcement, a debtor may challenge the registration or declaration because there's a ground for refusing recognition and enforcement under Article 22 of the Convention. So let's look at that article. Article 22 lists the grounds for refusing recognition and enforcement. The first is that recognition and enforcement is manifestly incompatible with the public policy of the requested state. The second ground is that the order was obtained by procedural fraud. Another ground is that there is a pending proceeding that was filed before the application. And another ground is that the registered order is incompatible with an order issued between the same parties, either in the requested state or in another state, if that order is entitled to recognition and enforcement in the requested state. In addition to those grounds, the debtor in the requested state may also raise these two grounds: lack of due process regarding notice and an opportunity to be heard if the respondent did not appear and wasn't represented in the state of origin, and that the order was issued in violation of Article 18 of the Convention. That article limits the tribunal's jurisdiction to modify, and there's a similar provision within Article 7 of UIFSA. We will discuss both of those modification provisions during Module 6 of the webinar series. A debtor may also challenge the registration or declaration because there's no basis for recognition under Article 20 of the Convention. The Convention doesn't establish particular jurisdictional rules, so you're not going to find any requirement that a contracting state has to change its laws regarding subject matter and personal jurisdiction. Instead, what the Convention does is set up indirect rules of jurisdiction. That means it doesn't matter what actual basis of jurisdiction the issuing tribunal used, so long as the facts would satisfy one of the bases listed in Article 20 of the Convention, the requested state must recognize and enforce the order. And that's why, when we were going through the forms, we said to make sure you check all of the bases that apply. As you can tell from this slide, some of the bases listed in Article 20 are similar to ones in Section 201 of UIFSA. But not all of the bases in UIFSA, Section 201, are listed in the Convention. For example, personal service on the respondent while present in the state isn't listed in Article 20 of the Convention, nor is intercourse in the state that may have resulted in conception of the child, nor is presence of the child in the state because of acts or directives of the respondent. On the other hand, there are bases listed in Article 20, those that are depicted on this slide, that aren't listed in UIFSA Section 201. One of those is the fact that the creditor was habitually resident in the state of origin when proceedings were begun. This is often called creditor-based jurisdiction, which the U.S. has taken a reservation to. However, if there's a U.S. order where jurisdiction was based on intercourse in the state that may have resulted in conception, and the creditor was still living in the state when the support proceeding was initiated, the requested convention state must recognize the U.S. order, because it would be a situation where the creditor was resident in the state of origin, and that is a basis for recognition under the convention. So again, what's important are the facts of the case, not the jurisdictional basis that the tribunal actually used. Next slide. As we discussed during Module 3, the Convention allows a contracting state to make a reservation to the 3 jurisdictional bases that are listed on the prior slide. The United States has taken a reservation to all 3, and if a contracting state makes such a reservation, it must nevertheless recognize and enforce the registered support order if its law would, in similar factual circumstances, confer jurisdiction to issue an order. And if you recall, we have that provision in the United States within Section 708 of UIFSA. A U.S. tribunal is never going to issue a support order under one of these 3 jurisdictional bases because they conflict with our legal concept of due process. So this particular provision of the Convention should never come into play with regard to a U.S. order that we're sending to another Convention country for enforcement. The Convention also allows a challenge to the authenticity or integrity of a document because elsewhere the Convention has done away with the requirement that you have to initially send certified copies. The delegates to the Convention wanted to ensure that if a document had been tampered with, for example, certain texts had been deleted, that there was a way a person could challenge it. The documents covered are the complete text of the order, or if the state allows the abstract or extract, the document stating that the order is enforceable in the state of origin, and the document showing the amount of any arrears. According to the explanatory report, if a certified copy of the document was already transmitted initially, it should not be challenged or appealed under Article 23. If there is a challenge, the Convention provides that the competent authority is bound by the findings of fact on which the issuing state based its jurisdiction. It also prohibits the competent authority from reviewing the merits of the decision. Unlike UIFSA, the Hague Child Support Convention doesn't contain any evidentiary provisions that apply when there's a challenge. That means each Convention country will apply its own laws regarding the admissibility of evidence. Again, the best source of information about a country's laws is its country profile available on the conference website.
Thanks, Meg. Now, we've covered a lot of material, so let's stop here and everybody take a breath and let's review some of these key points. Does every Convention country use a registration procedure similar to the registration procedure under UIFSA?
No. Some Convention countries use a declaration process. It's slightly different from the registration process, but it's still going to be very expedited and it will comply with Convention requirements.
And can a competent authority in the requested state refuse a declaration or refuse recognition simply because it doesn't agree with the U.S. decision?
No, the only basis that a competent authority can refuse a declaration is on the ground that recognition and enforcement would be manifestly incompatible with the public policy of the state. So that should be really rare.
Thanks.
So on Section 604 of UIFSA contains the choice of law rules that govern Convention proceedings in the U.S., but Convention countries are going to be following Article 32 of the Convention. It's very similar. First bullet, the law of the state addressed, in other words, the law of the forum, governs enforcement procedures and remedies. The law of the Convention country that issued the order governs duration of support. And the law of the issuing country or the law of the state addressed, whichever is longer, governs the statute of limitations on arrears. And I will turn it over to Bill.
Thank you, Meg. Now we're going to talk just a little bit about the status of the application. Within 3 months of the acknowledgement, the requested central authority must provide a status update to the requesting state. This time frame is a Convention requirement. Most countries will use the recommended Status of Application report published by the Hague Conference. There are status forms for each of the applications, so in the cases we're discussing today, you should be receiving the status report that relates to an application for recognition and enforcement. The status form begins with the standard notice of confidentiality and personal data protection. It provides contact information for the requested central authority and identifies the person in the requested state who can provide information about the application. There are tick boxes to indicate whether this is the first status report, that is the one required 3 months after the acknowledgement, or a subsequent status report. Section 3 of the form, which is not shown, provides information that identifies the relevant application, the 4D case number, the names of the applicant and debtor, and the names of the persons for whom support is sought. It will be based on information you provided in the transmittal that accompanied the application. Section 4 is where the requested central authority will indicate the current status of the application. It will use the first tick box to state that the competent authority has declared the order enforceable or registered the order for enforcement. The second tick box would let you know that the order has not yet been declared enforceable or registered, but that it is supposed to occur on or before the specified date. The requested central authority will use the third tick box if the respondent has timely challenged the declaration or registration. Tick box D indicates the competent authority has refused recognition and enforcement. This is the tick box that will be used if the respondent is successful in his or her challenge. Note the additional tick boxes related to notice of the decision on the parties. We discussed tick box E during Module 3. If the competent authority refused recognition and enforcement due to one of the three possible reservations to jurisdictional bases that the Convention allows, this tick box would be checked. There is also a place for entry of the date the competent authority established a new support order, assuming that has occurred. Tick box F is for noting any further appeal of the tribunal's decision. Tick box G states that the decision was sent to the enforcement authority. This should occur automatically once the order is recognized. There is no need to file a separate application seeking enforcement. The requested central authority will use tick box H if the application is still pending. Because the first status report isn't due until 3 months after the initial acknowledgement, hopefully that much of a delay will be rare. Tick box I is related to enforcement of the registered convention order. Although the order may be recognized and enforceable in the requested state, the debtor may be unemployed and lack other assets. In other words, the order is enforceable, but currently cannot be enforced. Beginning with Section 5 of the form, there are tick boxes related to past steps that the requested central authority has taken with regard to enforcement. Most of the tick boxes identify the particular enforcement measures initiated. The United States played a major role in ensuring the form has a comprehensive list, so most of these enforcement measures should be familiar to you. Whereas Section 5 of the status form focuses on past steps, Section 6 focuses on present steps being taken. Section 7 of the form lists future steps that will be taken. The requested central authority may use the tick box in Section 8 to request any needed additional information or documents. It will use the tick box in Section 9 if the competent authority has refused the application on its own motion because of a declaration or registration would be manifestly incompatible with the public policy of the state addressed. Tick box 10 is important. This is where you will learn if the respondent has challenged the declaration or registration of the order, and if so, the grounds for the challenge. The requested central authority will use tick box 11 if it itself is refusing to process the application for one of two reasons. The first is that you did not produce the documents or information within the required time period. The second is the rare situation that it has determined that the requirements of the convention are manifestly not fulfilled. In that circumstance, it must provide the reasons for that decision. At the bottom of the form is a place for the name of the person completing the form. I'm going to turn it back to Meg.
Thanks. In most cases, the result of the application for recognition and enforcement will be that the order you sent is recognized and enforceable in the requested state. But the Convention recognizes the possibility of partial recognition and enforcement. For example, if there's a dispute about arrears, the tribunal can recognize and enforce the order with regard to current support while the challenge about arrears is underway. And in some cases, the competent authority will refuse to recognize the order because the non-registering party has proven a valid basis for challenging the recognition and enforcement. The fourth possible outcome is in some cases, the support order cannot be recognized because of a reservation that the contracting state has made under the Convention. And as we noted before, that should not come up in a case sent by the United States. So I'm going to turn it over to Phil to from here.
Thank you, Meg. I'm conscious, everybody, that we're at the end of our hour and a half, but we have just a couple of slides here for just to present a case scenario. In this case, the custodial parent and the child live in Florida. The non-custodial parent lives in Sweden. She has a Mississippi support order that she wants enforced. She has applied for 4D services in Florida. What steps should the local Florida Child Support Office take?
Well, the caseworker needs to make sure, one, that the application is available to the parent, and an application for recognition and enforcement is available to the creditor. The application has to be within the convention scope, and since we're talking about child support here, it certainly is within the scope. The order has to be issued by a contracting state, and this is a Mississippi order, and the United States is a contracting state. And finally, the worker has to make sure that he or she has all the required additional documents, including any needed translated documents.
Great. And we'll assume that Florida has completed the application and rounded up all the required additional documents and transmitted everything to the central authority in Sweden. What steps should the Swedish Social Insurance Agency then take?
Well, as the requested central authority, it's got to timely acknowledge the application, and it should promptly forward the application and documents to the competent authority in Sweden. That would be the authority with power to declare the Mississippi order enforceable or to register the order.
And following registration of the convention order, what steps should the competent authority in Sweden take?
Well, those are the ones listed on the slide. They need to send the parties notice, if we can go back. Notice of the declaration or registration. The competent authority, in one case, can make an ex officio review of the application, and that would be, it could declare that it will not recognize the order because it's manifestly incompatible with the public policy of Sweden. And if there is a challenge raised by the respondent, then the competent authority has to comply with Article 23.
Great. And let's assume that the respondent challenges the registration on the basis that the support amount exceeds his ability to pay. May the competent authority in Sweden refuse to recognize and enforce the U.S. order on that basis?
No, that's not a permissible ground for challenging registration. Obviously, lack of income may affect the ability of the requested state to take certain enforcement measures, but if that's the only challenge, the competent authority in Sweden must still recognize the Mississippi order as enforceable in that country.
And if the respondent challenges registration because the Mississippi order requires support to age 21, but the law of Sweden only requires support to age 18, is that a valid ground for challenge?
Nope, that's not either. Article 32 of the Convention provides that duration is governed by the law of the country that issued the order, and the mandatory scope of the Convention requires Sweden to enforce current support through age 21 if that's what the order requires. So it will have to enforce the Mississippi order to age 21.
Great, thank you, Meg. Now, everyone, you probably have lots of questions about implementing the convention in the United States, and OCSC's Division of Policy and Training will continue to issue guidance on these implementation issues. To address the immediate needs of questions and guidance, the division is hosting this webinar training series, and this module discussed the most common application, recognition and enforcement of a convention order. Module 3 focused on incoming applications to the United States, and this module, Module 4, discussed outgoing applications for recognition and enforcement from the United States to a convention country. Please note the dates and times of the next trainings in your calendar, and there's a mistake there on the slide about Module 5. It says it will be on April 5th. That is not right. Module 5 will be on April 6th. Module 5 on April 6th. And at any point in the next half hour or tomorrow or next week or next month, please do not hesitate to contact OCSC at the address on the slide with any questions you may have or with any feedback on the webinar content. And you also have Meg Haynes' email address there. She's an attorney with the Center for the Support of Families, and she was a member of the U.S. delegation to The Hague during the negotiations. Thank you for attending this webinar.
And thank you all for participating in today's conference. That does conclude this call. Please disconnect your lines and speakers stand by for post-conference.